Hello, I'm Mark Nelson. I'm a writer analyst with Wolters Kluwer Law and Business. Specifically, I work in our Federal Securities Department where I focus on a number of issues, including SEC disclosure review. The impending Twitter Incorporated IPO gives us a good chance to look at some of the cutting-edge issues that the SEC staff have commented to a number of companies on over the last several years. Because Twitter is both a social media company and it's a technology company. Even more importantly, Twitter has taken advantage of some of the provisions within the Jobs Act, which became law back in April of 2012 and was intended to kind of spur the economy by promoting the growth of jobs at small, innovative companies such as Twitter. Twitter, about a month and a half, almost 2 months ago, announced, unsurprisingly via Twitter, that it had plans to do an initial public offering in the relatively near term. That tweet also revealed that Twitter had in fact confidentially filed its registration statement with the SEC staff for a non-public review. At that time, many members of the media and some investors questioned, well, how can Twitter do that? I thought registration statements were supposed to be public at all times. And in fact, under Title I of the Jobs Act, companies that fit the definition of emerging growth company may in fact submit their registration statements to the SEC for non-public confidential review. Eventually, of course, these registration statements must be filed on EDGAR. In fact, there's a requirement that 21 days before a company begins to conduct roadshows, it must file its original registration statement and any amendments to that document on EDGAR before beginning those roadshows. Just this past week, Twitter did begin conducting roadshows. Just as a brief aside, as part of that roadshow process, Twitter did get sued by a couple of advisory firms alleging that Twitter had kind of scotched a deal that they had with another firm who had a deal allegedly with Twitter to have these advisory firms go out and procure investors for a roughly $280 million exempt offering related to Twitter's IPO. The purpose, according to the complaint in that case, was that this exempt offering would help to remove overhang, which had caused so many problems with the Facebook IPO about a year and a half ago, and for which I think NASDAQ, where Facebook is listed, had set aside reserves of about $62 million to pay claims, and I think FINRA recently narrowed those claims down and reduced the total amount of compensation to about $42 million. If you have a chance, the complaint against Twitter is an interesting read. It gives kind of some real-world perspective, I think, on the kind of problems facing social media and technology IPOs, and in particular emerging growth companies like Twitter who are conducting IPOs. It's too early to say where that case will go, but as I said, it's kind of a good read if you have the time, and it will give you some insight into things that are happening right now in the technology and social media areas with these IPOs. We can, however, even though the SEC staff has not yet released the Twitter comment letters on EDGAR, typically they will do that about 20 business days after the close of a disclosure review, sometimes much earlier, sometimes much, much later, even years later, but probably we'll have those sometime later this year or early next year on EDGAR to look at, and then we'll know for sure what it was the staff asked. But even now we can kind of begin to speculate or infer what the staff may have asked Twitter about based on questions the staff has asked other technology and social media companies over the last 2 years, and in particular the kinds of questions they've asked of emerging growth companies. As I mentioned, Twitter is an interesting case for us to look at because it is both an emerging growth company and a social media company. And one of the first questions the SEC staff probably asked Twitter is, what are your revenues? And we know for emerging growth companies, in order to claim that status, you must have less than $1 million in total gross annual revenues. Twitter, by all published estimates, has about half that, and their revenues probably are even a little bit less than that at this point, according to their most recently amended Form S-1, which has been filed on EDGAR as of November 4, 2013. Another question that the staff will ask is, how do you make your money? And in particular here, the staff will want to know about advertising revenues. They'll want to know especially how what is called a monthly average user will be exposed to revenue-generating advertising. And although we don't know Twitter's response to that question, or if the staff even asked about it, other companies have explained how that works. And basically, it is dependent largely on how they define monthly average user. And I'll quote here briefly from Twitter's registration statement, which probably suggests what their answer to a staff question was on this point. Said Twitter, "We define MAUs, or monthly average users, as Twitter users who logged in and accessed Twitter through our website, mobile website, desktop, or mobile applications, SMS or registered third-party applications or websites in the 30-day period ending on the date of measurement. Average MAUs for a period represent the average of the MAUs at the end of each month during the period." Twitter disclosed in its most recently amended Form S1 that it has about 232 million MAUs at present. It also disclosed that most of those MAUs are outside the US. Another question that the staff probably asked Twitter about is the many Jobs Act elections and exemptions that are available to emerging growth companies, such as Twitter. One of those questions will be, if Twitter did not say so on the cover of its prospectus or registration statement, the staff will almost invariably comment that they need to disclose that emerging growth status in those areas of those documents. And the staff has actually been quite aggressive in telling companies that they appear to fit within the definition of emerging growth company and therefore should disclose that fact in their registration documents. Twitter did note, probably in response to a more general staff question about its elections, that its public perception by investors could be affected by some of its elections, or some of the ways it decides to treat itself under exemptions available under the Jobs Act. For example, Twitter said, and I quote here, "If some investors find our common stock less attractive as a result of any choices to reduce future disclosure, there may be a less active trading market for our common stock, and the price of our common stock may be more volatile." Another side to this question about emerging growth company status is that the company will often ask companies claiming EGC status to disclose how they could lose that status. And of course there are some ways, but probably the most typical would be that they simply get above the threshold amount of $1 billion and no longer financially qualify as an emerging growth company. Another area of interest to the SEC is the exemptions available to emerging growth companies in the areas of internal controls disclosure and executive compensation. Here there is the Jobs Act provides for an exemption from the internal controls auditor attestation requirement of Sarbanes-Oxley Act Section 404B. It also provides an exemption from the say-on-pay and golden parachute provisions of the Exchange Act. Those provisions had been added back in 2010 by the Dodd-Frank Wall Street Reform and Consumer Protection Act. With respect to Twitter's internal controls, this is what the company had to say in its most recently amended Form S1. And again, I'm quoting here. "We are not currently required to comply with the SEC rules that implement Section 404 of the Sarbanes-Oxley Act, and are therefore not required to make a formal assessment of the effectiveness of our internal control over financial reporting for that purpose." Twitter did go on to say that when it does become a public company, it will have additional duties in this area under the Sarbanes-Oxley Act. It also said that it must comply with a more robust version of the Sarbanes-Oxley Act disclosures once it ceases to be an emerging growth company. Twitter, of course, said that its stock price could be affected by any kinds of internal controls issues that it might, at some time in the future, disclose publicly. Another area that the staff has expressed a lot of interest with respect to emerging growth companies is the decision or the option to elect into or out of a regime where the company can either extend its period of being exempt from certain new or revised accounting standards, or it can opt in to follow those standards just as any non-emerging growth company would. In Twitter's case, it did something that a lot of companies aren't doing at the moment. It decided to irrevocably opt in, irrevocably opted to treat itself as if it were a non-emerging growth company. And the key word here is irrevocable election. The SEC staff comments to companies in this area have made it very clear that the Title I of the Jobs Act on this point does not allow a company to kind of hem and haw or opt into accounting standards they like and opt out of ones they don't like. It's a one-way election, and it must be irrevocable to either extend the period where you may choose not to comply with these requirements until they apply to all companies, or you either opt to be treated as if you were not an emerging growth company. With respect to this election, the SEC staff has actually required many emerging growth companies to include a risk factor, stating that, and here we'll paraphrase from a number of comment letters, that the emerging growth company's risk factor must say that its financial statements may not be comparable to those of companies that do comply with public company effective dates and other accounting standards. And they must include this disclosure also in their MD&A critical accounting policy section. One last item that the SEC staff has looked at kind of closely with emerging growth companies is the area of testing the waters. This is kind of a new thing for emerging growth companies to be able to go out and try to gauge interest in their IPOs before they actually happen with the blessing of the law. In this case, the Jobs Act allows emerging growth companies to test the waters in oral or written communications with qualified institutional buyers and institutional accredited investors. In fact, the lawsuit against Twitter that I mentioned earlier for common law fraud regarding the exempt offering to remove or attempt to remove overhang in the impending Twitter IPO kind of falls into this category of where Twitter was kind of alleged of kind of reneging on representations it allegedly made to these advisory firms that were to procure investors in the exempt offering because it was supposedly surreptitiously or not so surreptitiously testing the waters or attempting to gauge interest in its impending IPO. And those are now the kind of the main issues that are arising in the technology, social media, and emerging growth company area. You really want to pay attention to comments about revenues, how companies make their money, especially if it's from advertising revenues. And with respect to advertising revenues, it's all about the monthly average users and how the company defines those metrics, how they use them, whether they're double counting those users, among other things. It's also about the Jobs Act elections and exemptions available for accounting standards, for executive compensation, for internal controls, auditor attestations, and how the companies are using the test the water provisions. So these are all issues that we should watch for all of these emerging growth companies and for Twitter as well. And we'll find out exactly what the staff asked Twitter about when they do finally release the comment letter dialogues with Twitter on EDGAR, which, as I mentioned, should happen probably sometime later this year or perhaps as late as early next year. For now, I'm Mark Nelson with Wolters Kluwer Law and Business. Thank you.